Hello and welcome to Homeowner Talk. My name is David Stone and I'm the president of Nevada Association Services. And this is my co-host, John Leach, a partner in the law firm of Leach, Johnson, Song, and Gruchow. Each episode we'll be here to talk about important homeowner topics. Whether they involve homeowner association issues or homeowner maintenance problems, we, along with our guests, are here to provide you with what we hope to be very useful information.
We also want to encourage our viewers to interact with us and our guests each episode, so please visit our website at homeownertalktv.com and send us your questions. We try to answer as many of your questions as we can. On this show, we're going to be covering HOA or association collection issues. Our first guest is Judith Hanson. Ms. Hanson is on the board, and she's the president for the Aliante Master Association. Judith, welcome.
Thank you. Thank you, David.
Tell our viewers a little bit about your background and how you became involved in your association and as a board member.
Well, I moved here in 2006, and prior to that, my husband and I owned our own business back in Indiana for 46 years. Because of that, I was involved with the financial end of the business. So when I moved here, I said, I need to get involved. It's either find a job, get out of the house, or get involved with volunteer things. And through that, I ended up getting on the Sun City Aliante board. I served as vice president in 2008. In 2009, I served as their treasurer. Recently reelected in 2010 to that board. Now I'm just as a director. When the homeowners board became a homeowners board for Sun City or for Aliante Master Community, I decided to run for that, and at that time it was 2008. Basically November. It should have been done in September instead. So I had a short term because I was on the 1-year term. And I moved in as treasurer at that. Stayed on treasurer for the second year. This year I am now the president.
Tell our viewers just how many units you have in Sun City Aliante and then in Aliante Master.
We have just a little over 2,000 in Sun City. And in the Master, we have 6,547. The Master was incorporated in 2002. We have 13 sub-associations. We have 7 neighborhoods, which are all distinct. And we have a nice commercial strip with 16 commercial businesses, basically, anchored by a major food chain. There are a number of banks within the area, and there are a number of restaurants. And most recently, of course, Aliante Station Casino and Hotel has been in the property. We have a lot of green space. We have 24 miles of walking trail in that area. We have 1,900 acres. We sit at the foot of Sheep Mountain, and to the north of us is the desert. It's a very pretty setting, and one that I enjoy doing a lot of walking in myself.
Well, Aliante is without question probably one of the most beautiful communities in the valley, and a lot of us, the viewers as well, have been there, whether it's to Aliante or to visit friends. It's really spectacular. And now you're the president, so it really is now another job. I mean, that is quite, it really is. Quite a few hats.
I was going to say, she thought she was probably busy before, and 6,500 homes that are counting on. How many members are on your board?
There are 7.
So a 7-member board who's implementing the policies for 6,500 homes, and then you have the commercial and other green belts and whatnot. Maybe you can tell our viewers what some of your challenges are.
Well, before I do that, I'd like to say that 4 of our members have our decals. There is a 5th member working on it, but more importantly, Sun City Aliante, all 7 of us have decals.
Yeah. For our viewers, a decal is the dedicated community association leader who has taken the courses requisite through Community Association Institute to receive that. And what that indicates is that the person has gone through an extremely large amount of education and training to better prepare themselves to serve on the boards.
Well qualified for the position.
Yeah, absolutely.
Sometimes I wonder if I am, especially with all the law changes and the upcoming NRS changes.
Sure.
And I would like to at least comment a couple more things about the Master Association. We do have our own golf course. We have 3 major parks in the area, and within those 3 parks we have bocce courts, volleyball courts, soccer fields, baseball fields. I don't think a lot of people realize that we have these things within, the confines of our community. So that's important.
It is critical.
Incredible.
To know that.
Yeah.
So what do you think some of the biggest challenges are confronting your board of directors?
Well, most recently, one of the challenges was to find builders to finish building out two of our communities, Providence and the Fields, so that the architecture matched what was already there. A second challenge is adapting the fact that we've got a 55 and older community amongst communities with children and so forth. So that's another challenge. Foreclosures is a big challenge. And the other one that I have, which kind of tugs at my heartstrings, is to get volunteers. In regards to foreclosures, we have a large delinquency. Unfortunately, I did not bring those numbers. Since I'm no longer treasurer of them, I don't look at those numbers on a monthly basis. But one of our challenges is the fact that so many of our homes are owned by military. And of course, you can't really foreclose on a military. You can get your assessments from the military, but you can't foreclose on their homes. And so when we start a process of putting a lien on a home or an intent to lien, we don't know that that home is owned by a military, which makes it, challenging and difficult. And so sometimes we get started on a process and have to stop the process.
So I know that the law currently requires all associations to have a collection policy, a policy that they're going to implement to try and collect those assessments. You brought out some great points, military issues and other things like that. Maybe you can share with our viewers a little bit about the Aliante collection policy, or why that's helpful to have that policy.
Well, it is helpful because it gives you an even playing field amongst all the homeowners. They know what is involved in collections. In 2002, the declarant had a collection policy, and of course, that was fine for them. But once the board took over, we had to do our own collection policy, and that's been published on the website that we have. It's been published in our magazine, the Aliante Ariel, and it is available. It goes out with all the budget mailings. It identifies that when we receive money, the money goes in a certain set, to assessments and then to late fees, interest. It also states within that collection policy that at 60 days we can file an intent to lien, and at 75, lien the property.
And that's very important. That's very important to have. But I think what's equally important, and I think which is sort of one of the shining stars of Aliante, is that the board, I'm well aware, works with homeowners. I know you encourage communication with your membership, and when you have that many people living in that community, you have to be able to listen to people, not just on payment schedules, but dealing with short sales. I know you're dealing with short sales right now. Communication is key, always.
And I have a great management company working for us and great staff right there in adjacent to the Aliante area. So it makes it nice for homeowners to be able to at least call and talk to a face.
And you have your management office right within the community, or just
no,
off
it's about 2 miles from the community.
Very close.
Yeah,
so you're never more than a few minutes away if you want to come in and speak to somebody.
Right.
We all know that the economy's been rough on residents in the valley, and you alluded to some of that by talking about the delinquencies. Are you finding that when your collection policy is implemented, even if you have to do the liens and start the collection or foreclosure process, are you finding that it is successful, that it's bringing in those monies?
Yes, it is. And the best part is if we can get these homeowners on a payment plan, at least they know that that money is going to par down, and that's important. Because if you're looking at a $700 or $800 charge, you don't have that money to pay it out right away. But if you can get on a payment plan where you pay on a monthly basis $150, $200, $225, it makes a big difference because you can see that you're actually able to stay in your home a lot longer because you're making those payments.
Well, we really appreciate your willingness to come on the show and share these thoughts with our viewers, especially, you've got to be the president of one of the largest communities in the state of Nevada, and so a lot of the things you do affect a lot of people. So we're so grateful that you share that with us today. After the break, we'll find out how Nevada Association Services handles HOA collections. So stay with us, and we'll be right back.
What gets you moving? Because when you get moving an hour a day,
you fuel your body
and your mind.
Whether you like to throw around the football,
play frisbee in the park,
or dance in your room.
Moving every day helps give you a healthy body and mind.
And that makes you part of a winning team. Hey, that was my line. Get up and play an hour a day, Doc.
Check out how to be a player at letsmove.gov.
Head online to get tips on great ways to get moving every day.
That's www.letsmove.gov.
Waves of foreclosures have slammed Las Vegas, the epicenter of the foreclosure crisis. The maze of paperwork and red tape can be daunting. Who do you turn to? Where do you start? StopNVForeclosures.org is a secure, city-sponsored website that will connect you to free, HUD-approved housing counseling. There's help out there, and we can help you find it. Visit StopNVForeclosures.org or call 229-HOME for more information.
Welcome back to Homeowner Talk. We recently visited with Nevada Association Services to get an inside look at the collection process. We'd like to share that with you now.
I've been with NAS since 1999, which was just a few months after doors have been opened. And before that, I was doing community management, which is very interesting, starting at community management and going to collections. It gives me a nice overall picture of the process. Well, to address what trends we're setting, first of all, we were one of the first companies to ever launch online status reports. We're trying to revamp that right now. We're having a lot of questions from managers. They want special financial reports and what's going on this day with properties. So we're customizing our reports right now just to make sure that managers are getting all the information up to date in real time. As far as dealing with managers one-on-one and board members, we are dealing with a lot of people daily who are faced with a lot more challenges now, trying to maintain their community with a lack of revenue coming in because of the economy. So there's a lot of one-on-one discussions. You know, each account is somewhat unique in a sense. So trying to really speak to the community managers and board members and keep in touch with them about how they would like us to proceed with these accounts. Maybe give some recommendations or advice. We're seeing great success. A lot of people, although the economy is in a bad place right now, we have a lot of people contacting us, homeowners, who want to pay their HOA assessments. They're not trying to be delinquent. And one of the things that we do to assist them is we do offer payment arrangements. You know, we have payment terms that we could customize for the homeowner. We'll contact the management company. If the homeowner needs, you know, a little bit longer of a term than we normally would, we'll see if we can get approval. And that's wonderful because the homeowner then feels comfortable with not having to pay off this whole debt at once. They'll make monthly payments to us, and then the association will be receiving funds from us on a monthly basis as the homeowner's payment comes in. So it's great, you know, as long as that communication is there, and you know we do have contact with the owner. It's something we always offer them. Homes are being sold again. We're seeing a lot of homes that have been foreclosed on by the bank. They're being sold now to, you know, individuals are coming out and they're not so scared to buy now because they're getting a really good deal. So we are seeing a lot of those bank-owned properties being sold. Also, we're getting a lot of requests. Homes are going through the short sale process. So that's something that we have to look at, you know, and speak with our clients directly, because there is something there that we're going to have to reduce to make the sale work. And everyone's normally more than willing to take off some late fees or for the collection company to waive some of their fees to make the sale go through, so that the community can now have an owner in there who's willing to pay their assessments. You know, coming from a prior community manager background, I know the challenges of preparing a budget and then trying to maintain that budget. So I could definitely feel for these managers now trying to keep gates operational or pools open or landscaping up to par. So it is a service. If these homeowners are responsible for paying their assessments, then, you know, by not paying them, they're hurting the rest of the community. So if we could get a homeowner to pay, that's great, because that's revenue coming into the community, and it's for the benefit of everyone in the community, not just the management company. I take great pride in working for this company. One of the reasons is the involvement we have with the industry. We're not just a company trying to better ourselves. We understand that to be a great company, we have to be aware of everything that's going on. We only do assessment collections. So that's our main focus from, you know, the whole entire day. It's all we're focusing on. We have people in our company who are involved in legislation. So we stay on top of current events and to know what's going on in our industry, what could change our industry. So all this information is very valuable, and it's stuff that we could pass along to our clients.
Now we'd like to please welcome Kirby Gruchow, Jr. He is an attorney, a shareholder with the law firm of Leach, Johnson, Song, and Gruchow. Kirby, first of all, I want to welcome you to the show. It's a pleasure having you here. We usually do our seminars together, so it's nice seeing you in this type of setting, but thank you very much for being here.
Well, thank you for inviting me, David.
Before we get into this, perhaps you can just give us a little background, your history, how you got involved with HOAs, law school, and so forth. We'd love to hear a little bit of your background.
That's a whole lot of things, but...
Well, we got time, so...
Well, I've practiced law for about 13 years now. I'm currently with Leach, Johnson, Song, and Gruchow. I started out my career in 1998 with Santoro, Driggs, Walsh, Kearney, Johnson, and Thompson. That's where John and I met each other. And we've practiced together for about 12 years now. We've been partners for a number of years. Great guy, love John to death. And I practice in common interest communities and bankruptcy law. I have other areas of practice too, but that's the focus of our show today. I have represented a number of HOAs as general counsel, litigation counsel. Of course, I do the bankruptcy work for the HOAs that need the work. The types of bankruptcies I've been involved in for common interest communities involve developer bankruptcies where the developers file bankruptcy. There's still transition issues involved. I've helped the HOA resolve the transition issues. The developer may owe assessments or reserve fund subsidies. I've helped the HOAs resolve those issues, as well as other types of issues involved in the bankruptcies with developers. Additionally, many bankruptcies are filed by individuals or corporate owners of the property. The HOA may have a claim for unpaid assessments or other obligations such as violation fines and outstanding violations. I've assisted the HOAs in prosecuting those claims and helping them get that resolved through the bankruptcy.
You know, when someone mentions HOAs and bankruptcies, you're usually one of the top 2 or 3 people that come into mind. I mean, you're always up there. How did you get so involved and develop such an expertise in dealing with community associations and particularly with bankruptcies? Because there's a lot of bad information floating out there, and you sort of are sort of the flagship of the person to go to when there's an HOA bankruptcy issue. So how did you get involved in that, and what are some of the unique aspects to HOAs in dealing with homeowners associations?
Well, first of all, thank you for the compliment. And second, when you're dealing with a bankruptcy issue involving a common interest community, what many people don't understand is that you have to deal with NRS 116 as well as the bankruptcy code. I'm not aware of any other attorney out there, and I don't mean to offend anybody if they're watching this show, but I'm not aware of any other attorney out there that has practiced in both NRS 116 and common interest community law as well as bankruptcy law and put the two together so that they can meld those two areas of law and practice productively in that. For instance, in my office earlier today, I was dealing with an issue with one of my associates trying to educate another attorney who is involved in bankruptcy but has never dealt with an NRS 116 issue or a common interest community issue. And as many people that are probably watching the show know, there's certain issues involving HOAs that don't involve other clients, such as the super priority rules, NRS 116.316, and the automatically perfecting statutory lien. And one of the things we were trying to educate that attorney on was that there is an automatically perfected lien, and the position that was being taken was that you don't have a lien until you've recorded one. And we disagreed with that, and we've been successful with that argument before in the bankruptcy courts and pursuing the claims, even though there wasn't a notice of lien recorded before the bankruptcy.
And I found in dealing with collections, that's probably one of the biggest misconceptions of our industry dealing with bankruptcy specifically, not only with attorneys, expert attorneys in bankruptcy, or so they claim to be, and board members, but the obligation to pay an assessment is a secured obligation. You don't have to record a notice of lien. We don't record liens in this state. We record notices of lien, and the lien is statutory. So you probably deal with it on a regular basis, as do we. And I don't think most people understand, and you can certainly elaborate on this, I don't think most people understand the significance in the fact that it's a statutory lien and that it's not a recorded document. It's by statute an automatic lien. And there are benefits to that I think is overlooked quite often.
And you're exactly right. You're exactly right. One of the first things that happens in a bankruptcy, if you're dealing with somebody who wants to contest the association's claim, is to argue it's unsecured because there hasn't been a document recorded to identify the amount owed. But what these attorneys or these individuals, if they're homeowners, don't understand is that by recording the CC&Rs, you've now had a recorded instrument on the property that identifies the obligations that are owed. And if they're not paid at the time the bankruptcy is filed, then there's an automatically perfected lien under NRS 116.3116, just by nature of having the CC&Rs recorded against the property. So there's no other recording necessary. The notice of lien is recorded to pursue the foreclosure process or for other reasons to put title or other people on notice there's an outstanding obligation.
And you do a lot of you do continuing education classes for community managers. I join you on some of those. And I know that's a recurring theme of the requirement, that the fact that there is no requirement to record a lien, that the lien is statutory. And that's always something we seem to be trying to impress upon board members, because I think in my experience, and I'm sure you've had this too, is that many board members and community managers as well feel that just because there's a bankruptcy and it's been discharged, that the association then is out of luck and they won't be able to collect their money. And that's simply not the case.
It's not. And a couple things that come up when a bankruptcy is filed. Many people think just wait and do nothing. That's the attitude. And a lot of times they have that attitude because they don't know what to do. But what I'll submit is that doing nothing is the wrong thing. At a minimum, you should look at whether or not you have a claim, whether or not the HOA has a claim, and if you do, file a proof of claim. And then monitor the bankruptcy, see if the assessments are being paid on a regular basis, because when an owner files bankruptcy, they still have an obligation to pay the what's called post-bankruptcy or post-petition assessments. Their obligation just doesn't go away because they filed bankruptcy. But there's a lot of homeowners and a lot of homeowners' attorneys who feel that is the case. So we regularly deal with that also. So what an HOA should do is monitor the bankruptcy to see if the post-petition assessments are being paid, and if not, then there's actions that can be taken to obtain the payment or go to the court and seek relief. Now, what happens when a bankruptcy is filed is that now you're subject to the court's jurisdiction, the bankruptcy court's jurisdiction, so you have to comply with the bankruptcy code. You have to ask the court for permission to do certain things. You can't continue your foreclosure actions. One of the things that happens when a bankruptcy is filed is what's called a 11 U.S.C. 362 automatic stay. What that does is it prohibits creditors, such as homeowners associations, from pursuing their claims against the debtors without seeking bankruptcy court permission. So it automatically stays creditors' activities, including recording of notices of liens or NODs or sending letters saying you owe this amount for the pre-petition balance. You just can't do those things. Mm-hmm. There are a number of things you can legally do, but you have to make sure that you comply with the bankruptcy code, the wording's right, and they're not violating the automatic stay, because there are some severe repercussions for doing so. Yeah, you have to get the okay from the court at that point for everything that you want to do. We only have a couple minutes left, and I want to touch on briefly some of the what you're seeing going on now with community associations in regards to collections in general. And any legal issues that you have seen have sort of popped up recently that might be on the radar in the last couple of minutes that we have. Maybe you can comment on any thoughts on that. Okay. The issues I've seen associations dealing with in collections is definitely an increase in collections, an increase in delinquencies. There's been an increase in bankruptcies. I just had a manager call me the other day, and one of the classes you and I taught that we teach 2 or 3 times a year, she said that she came to the class and she felt like she learned a lot, and she only had a few bankruptcies, so it wasn't really important at that point in time to do something more to educate herself. She said in the few months since she had attended the class, the number of bankruptcies had quadrupled. So just in a few months, they went from very few to whatever that number was. And it just ballooned up. It ballooned up, and she was in the 20 or 30s now in a community that previously only had 6 or 7, The other legal issues that I've been seeing associations deal with are foreclosures and the magnitude of foreclosures. It probably doesn't surprise anybody to hear that. But it depends on if you're an association that's in a gated versus non-gated community. There's different issues that crop up, like access issues. I was just talking to a client the other day about they have a property that's been foreclosed. The bank hasn't recorded the deed yet. There's still a person living in the property. They haven't been evicted. What do you do with access controls? These issues are cropping up. Or the deeds aren't being recorded in a timely fashion after the foreclosure sale. Now, there's a statute that says you're supposed to record within 30 days, but there's really no repercussions if the banks don't do it. Yeah, there's no teeth in the requirement to record your deed, and that would certainly help out the association. Kirby, thank you very much for offering all that information. It's been very useful.
And when we come back, we'll answer a viewer question, and we'll be right back with John. Thank you.
If you're a small business owner in search of affordable office space, the Urban Chamber of Commerce and the City of Las Vegas Redevelopment Agency have a great opportunity for you. You could become part of the Urban Chamber of Commerce Business Development Center, a 17,000 square foot facility offering flexible spaces that can be used for office or light industrial purposes. Just fill out an application. The forms are available at urbanchamber.org and lvrda.org, or call the numbers on your screen for more information.
Congratulations. I'm sure you'll have many happy years here. Except for you, because you'll be gone 3 years from now, struck down by the same disease that got your father. Sadly, it could have been detected early with a simple test.
For a list of tests every man should have, go to ahrq.gov.
Hello and welcome back to Homeowner Talk. We received a viewer question from Stan. And Stan asked the question, if my HOA ends up owning a house from a foreclosure sale, will our HOA be responsible for paying the mortgage payment? And what about insurance on the property? John, what are your thoughts on this one?
David, the Reader's Digest answer is no, you do not have to pay the mortgage. The mortgage is a contract between the former owner and the lender. The association is not in privity to that contract and has no obligation to make the payment. But it brings up the reality that eventually someday the mortgage company or lender is going to decide that we haven't been paid and we're going to foreclose on the property.
And that's perfect.
Yeah, they can. And so eventually the property that the association purchased at its foreclosure sale may be foreclosed by the lender, and the association would then be divested of any ownership in it. But during the time that the HOA owns it and the time that the lender ultimately forecloses, the association does not have to pay the mortgage. The other issue, though, which is a little more delicate, is insurance, because once you own the property, I don't know what the association is going to do with it. If they're going to lease out that property, and there's people that are occupying the property, there's a liability issue. It's your property. If it's not insured, then could you be liable if there's a slip and fall or accident on the property? The answer is yes. So the association needs to take steps to make sure that that the property is insured, all from that risk liability issue. But again, the mortgage as an answer is no, and insurance, I think they really need to look into that to protect themselves from any potential liability.
And I think that's one of the most common misconceptions. If an association, in the very unusual case that they do foreclose on a piece of property, I still get comments from boards saying, do we need to pay the mortgage? And they're worried that it's going to affect the association's credit or something like that. And I spend a lot of time explaining to them they have no obligation to do it. The bank may take the property from the association if no one's paying them, but that's fine.
The only credit that's affected is that of the former owner, so they can sleep better tonight.
Absolutely. We encourage all of our viewers to ask more questions through our website, homeownertalktv.com. And I want to thank our guests, Judith Hanson, Debbie Kluska, and Kirby Gruchow.
And that's all for this edition of Homeowner Talk. We'd like to thank our partners on this show, the Management Trust, Alliance Association Financial Services, Classic Landscapes, Western Risk Insurance, and Nevada Association Services. Remember, you can always find information about this program, and you can also drop us a line at homeownertalktv.com. Thanks for joining us, and we'll see you next time right here on Homeowner Talk.